discussion. So I really encourage you to ask any questions that you might have given these important laws that are coming into effect that affect all of us. So I might hand over to you, Steve, if you're happy to get started, and we can take it from there.
Sorry, Emma, I'll just do a quick audio check to make sure you guys can all hear me.
Fantastic.
Perfect, thanks. So what I might just do now is share my screen for a PowerPoint presentation. So I'll just pull this. up. So I can see all of you on the side, and I can see the screen there. So hopefully that's all working well. To echo Emma's comments, if you'd like to raise questions throughout the session, please do. I'd like to have a chat about this important topic in a way which is really meaningful to you as participants. What I'm presenting to you today is a session we presented to the Victorian government when the new laws were foreshadowed, and I've recut this to just bring it up to date for where we are now with the introduction of these new laws. So there's references to government departments throughout this, but that's not to suggest that doesn't apply equally to your sector in terms of the content that we'll be delivering. The upshot, the takeaway message, I suppose, is this: that there has been for quite some time a heavy focus by WorkSafe on fatalities occurring in Victorian workplaces under existing laws today under the Occupational Health and Safety Act. They are routinely investigated by WorkSafe. They're routinely the subject of Criminal Health and Safety Act breach prosecutions. And one of my colleagues, Julie, I think is dialing into this call. Julie and I would, quite routinely act for our clients in the criminal courts, assisting them respond to occupational health and safety prosecutions. That exists, today. What has happened with the introduction of these new laws is that there's been two new offences that have been introduced into these new laws for businesses, for employers, and for their officers, which say that in the event of a workplace death, there is a heightened set of potential penalties or consequences for those who've directly caused the death at work. It's not to say that as we stand here today, and these laws will come into effect on the 1st of July, it's not to suggest that today that there is anything other than, a strict need to focus on fatal risk in the business. But in the future, there will be an increased legal risk for organisations that have had deaths in their workplaces, deaths caused by the way in which those businesses are run. And so I suppose that's my headline point, that fundamentally nothing changes with the introduction of these new laws. We still owe an obligation to ensure that everything we do minimises or reduces the risk of a fatality occurring for our business. And, that might sound self-evident, but I think it's important that we, kind of calibrate this change in that context. But in the event of a workplace fatality, there will be now a much more serious investigation and a much heavier potential legal risk at the back end. And so as you stand here today in your organisations, you'll do everything you can to protect your workers and those, clients that you look after from fatal risk. Of course, that is a natural part of what you do. So what you should do today doesn't fundamentally change, but the risk of getting it wrong is increased, the potential penalty is increased. So what I thought I would do today is to walk you through what I thought would be a useful way of explaining what this means. And we'll start with some context. I'll take you through what the legal elements would have to be to prove a workplace manslaughter offence in hopefully a practical way that gives you a sense of what that would look and feel like, and then I'll give you a sense of what it is I recommend organisations, including organisations like yours, do. So there's going to be a lot of talk about death today, and it's unavoidable, I'm sorry, in the context of a workplace manslaughter discussion. So I just make a preliminary point. It's a terrible thing, of course, to have anyone die at work. Putting aside the law, I've done this for a while. I've done this for 16 or 17 years now. And I can tell you no business is the same after they've had a death at work. There's a legal consequence. They go through courts, they deal with lawyers, they do all of that. But organisations are never the same. They've lost a colleague, they've lost a client. There's a pall that sort of hangs over the organisation as a result of these deaths. So I just make the observation, I suppose, that to a very large extent, organisations should not be driven by managing legal risk in terms of looking after people and making sure there's no deaths at work. And so we'll talk today about the consequences of these new laws and whether they were needed at all, whether that was a legal need at all. But I just wanted to make the preliminary point, nothing in that discussion is intended to, downplay the seriousness of what it is to have a death caused by your workplace. I wanted to set a context as well, which is, while the work that the organisations on this call do plainly fills sort of a critical social need in no doubt budget constrained and maybe even in the future further budget constrained circumstances, there is no propensity, no willingness from WorkSafe to give a free leave pass to organisations in terms of managing occupational health and safety. So notwithstanding that you may deal with violent or aggressive clients or people in your care, and that to some extent that's an intractable part of the role that you play, there is still an expectation that we positively, as far as we reasonably can, manage the risks associated with that. Today, and it's a matter of public record, we're helping the Department of Justice in relation to 2 prosecutions that are arising out of workplace violence incidents that occurred in youth justice facilities. So you might say, well, what are you to do if you take a violent offender, you take them out of the community and put them in a corrections facility? You're on a public policy basis, taking them out of the risk of harm of the community and putting them in a workplace. How can it be that workplace is then susceptible to prosecution for not managing that risk? You almost introduce that risk as a matter of what the state or the courts have done. But the regulator sees it differently. They say that is a predictable, known hazard or risk, and you should proactively say, what is it we can do that manages those risks? It's not to say that every incident of occupational, physical or psychological violence is a breach of the Health and Safety Act, but it's equally not to say that because these things are visited upon us by external factors, we're immune from having to think through the risk controls. And just one other observation, again, by way of setting the scene, that at present there are, I think, about 6 prosecutions of state government agencies, so not necessarily organisations like yours, although there are some that are very analogous. Departments of Justice, 2 occupational violence prosecutions against the Department of Health. So I just make the observation that there is something of a focus on the public sector, and in particular in this occupational violence and risk area from the regulator. And it's not to say that is going to be, the first, as it were, cab off the rank for a workplace manslaughter prosecution. But it would very much be, within the realm of the policy objectives of the regulator. And so I suppose it's just my way of saying, this is, a timely discussion to understand the impact of these laws. So context is very important, I think, in understanding what these laws are all about. To be fair to governments, most of the time that a new law is introduced, it's introduced because there's a gap, there's a legal need. A regulator may have taken a law to a court and the law has failed to achieve the justice requirement that the community would have. Because, clever defence lawyers like us have found a loophole in the law, or the courts have said there's not enough sentencing power, we need to be tougher on offenders. So there's often a legal need that leads to the introduction of a law. And one of my messages for you today is I'm not sure that is true about these laws, about the introduction of these industrial manslaughter laws. And I'll explain what I mean this way. Leading into the last state election, and echoing the approach that the Queensland, the Palaszczuk Labor government took to their preceding election, there was a policy position from our government that it would introduce a workplace manslaughter offence. Now, I'm neutral on whether that's the right or wrong political thing to do, but it is critical, I think, to understand that the genesis of these laws was not that the existing Health and Safety Act failed to protect people from fatal risk at work. Instead, the genesis, the reason these laws were introduced, was effectively as part of a political positioning by government leading into the election, and principally driven by, and there's no surprise or no secret in this, but principally driven by unions, and in particular the CFMEU had a particular focus workplace manslaughter. And that was very clear from, you know, what they said publicly. And again, I'm not to suggest anything conspiratorial, but it's important, I think, to understand that these laws were introduced as part of really a political commitment that was made as part of the Labor Party's national platform leading into the last election. As we all know, they won that election in a landslide. And immediately after that election, or very soon after, the state government put together a panel of stakeholders to answer the question, what should the new workplace manslaughter laws look like? And that panel included union, representatives and employer representative bodies and others, and a range of people. But the bulk of it was made up by people who had been personally affected by a workplace death. People who'd lost a wife or a husband, father or mother, someone who'd lost a colleague at work. So people who'd genuinely been touched by, the scourge of dying at work. And they said to these people, what would you like those laws to look like? And they want probably what you and I would want if we were touched by this, that they wanted severe punishments. They wanted a strong message that it was intolerable in our society that there could be a death at work. And that's effectively what we've got, a law that imposes a reasonably high standard. I'll talk to you about the process in a second to prove a manslaughter, but that carries an enormous stick, 20, soon to be 25 years jail, up to $16 million in fines for companies. A very, very severe stick for those who are criminally negligent and there's a death that results. Now, again, I'm judgment neutral on that. That is, a perfectly reasonable thing for that group of people to recommend. As I say, I think if you put me in a room and I'd lost a son or a daughter in those circumstances, of course you would say we need extremely strong punishments in relation to this. But I suppose I make the other point, that on the other side of that coin, you might say, well, were the existing laws so inadequate that we couldn't also achieve, that sense of community justice? And the answer, I suspect, is no. Existing health and safety laws, so the law today as it exists in Victoria, already carries an offence that carries the potential for jail time. So this sort of, kill a worker, go to jail idea, that we needed that in the Health and Safety Act, it already existed. There was an offence today that sits in the Health and Safety Act in our section 32 that says if you recklessly endanger somebody and that exposes them to a risk of death or serious injury, i.e. and they die or if they're seriously injured, you can be prosecuted and sent to jail. But in the years that provision has been there, some now, 16 years or so, it's only been used twice by the regulator. And that's an unusual thing, right? If we're having this debate about the need for tougher penalties or for more serious consequences, it's a bit of a stark contrast that the existing most serious offence under the OHS Act has actually only been used twice. And no one's ever gone to, we've only had one person who's had a custodial sentence in that whole history. And so again, I make this all by way of context because I think it's important that we kind of calibrate that there is not a long queue of offences that are waiting to be prosecuted under these manslaughter offences. It's not as if the existing law has been pushed to its absolute limits and we needed this additional thing. And it's not as if there's been a propensity by our regulator to bring those most serious offences. It's a very rare thing. But that being said, these laws are there now, and it will be a feature of an investigation into any workplace fatality, frankly, that this will be, the spectre of a workplace manslaughter prosecution will exist. So with all of that being said, you might be wondering what the laws are all about. So what happened late last year was the OHS Act was amended with laws due to come into effect on the 1st of July. That was, back in the day when we could all go to cafes and we all went to workplaces. They toyed with the idea, for what it's worth, of adjourning the introduction of these new laws in light of COVID, in light of what was happening, in light, I suspect, of the sorts of pressures that have been put on agencies like yours and like others. And that decision was not taken. Government has not deferred the introduction of these new laws, so they will come into effect on the 1st of July. There's been a trend over the last few years of increasing penalties under the Occupational Health and Safety Act. There was an amendment to that, that section 32 provision that we just spoke about, reckless conduct. A few years ago, the maximum penalty for a company went up to $3 million to match New South Wales, to be frank, because, you know, we've always got a match New South Wales. So there's been a trend up of penalties and potential penalties under the Act. But of course, this is a serious additional penalty in relation to that. So let's go through what this will look like to prove criminal workplace manslaughter. And I make an observation that these laws can apply to both individuals and to companies, corporates. So it is possible in the future we will have a corporate entity which is prosecuted for workplace manslaughter and has that on its corporate criminal record. And to be frank, if you look at the lived experience of other jurisdictions that have had these laws, the UK's had them for about 12 years or so. Most prosecutions are against companies, not people. And so at a high level, I'd just make the observation that most prosecutions are likely to still be, as they are now under the OHS Act, at a corporate level, not necessarily an individual level, but that there is separate individual risk as well. And so we need to bear that in mind as we go through. There are 4 things that really need to be proven following a workplace death. So again, that there has to have been a death for it to be a manslaughter. There are 4 things that need to be proven. First, that there was a health and safety duty owed by that person which has not been met. Secondly, that there's been a death which has been directly caused by that there's a relationship between that poor non-compliance and the death. And then the last 2 elements are that the behaviour that's led to that has to be what's referred to as negligent, and I'll come to that in a second, but it has to be negligent to the criminal standard. I'll explain to you what negligent means. So let's just go through that to start with. There has to be a duty that is already owed under the health and safety laws today, as it were, before there can be a risk of a workplace manslaughter prosecution. So what the legislation actually says is that you have to owe a duty to somebody else, and you have to have not complied with that duty in a way which is criminally negligent enough to prove the death. So in simple terms, what that means is that we're not extending the types of obligations which are owed under the Occupational Health and Safety Act, although we are plainly introducing a new legal risk, a new legal jeopardy. But in a practical sense for you, for your organisations, you owe a duty to in a corporate sense, you owe a duty to your direct employees, you owe a duty to your contractors or labour hire workers to the extent you've got control over what they do. You've got a duty to your stakeholders, clients, members of the public and others, again, affected by what you do. So what will happen in the future is, having owed that duty, if there's a failure to comply with that duty and there's a death, then there can be a manslaughter prosecution. Of interest as well, you might also have a sense that, well, doesn't everyone owe a duty to everyone under health and safety law? Every worker owes a duty to themselves to comply with the health and safety procedure, and to people who are affected by what they do. And that's true. That is the law under the OHS Act. So every worker owes an obligation to themselves and to others. So to give you an example, do you remember when planking was a thing, where people used to lie straight and take a photo? So there's a couple of people got done for planking under the OHS Act. They were not taking reasonable care of themselves. And WorkSafe had a photo, because that was what you used to do. You put it on Instagram, and they prosecuted these 2 guys for planking. Blast from the past. But these laws apply. And so those people went to a court, they were charged with a criminal offence, they got a fine, it was like $8,000 or something, but not to be sneezed at. And so that's the existing law. So in introducing these manslaughter offences, the choice of government was, do we extend those worker duties to include manslaughter, or do we not? And they've chosen not to. So the government has, passing these new laws, expressly limited the people who can be prosecuted under these laws to be companies, corporate entities, associations, their officers. We'll come to an officer in a second, but not every worker in the organisation. Every worker cannot personally be prosecuted for manslaughter. They can be prosecuted for recklessly endangering someone else. These are fine legal distinctions, but reckless endangerment, knowing there's a risk, turning a blind eye, or turning a blind eye so you don't see the risk, one of those 2 things. Someone who does that is still at risk of investigation and prosecution by WorkSafe forgetting manslaughter laws. But for these manslaughter laws, these really serious provisions, the decision from government was to exclude employees from their coverage. Now, again, perhaps as an editorial comment, you might say, well, where's the logic in that? If somebody goes to work, causes the death of somebody else, and is criminally negligent in the way that causes it, surely they should be punished. They should be seriously punished. Well, the decision was not. The decision was that they should only be susceptible to the existing risk, which means unless there's a reckless element to it, they can't be at risk of going to jail. And again, that's on a neutral basis, simply a decision that's made in the drafting. From a health and safety point of view, it's a confusing message, isn't it? I mean, it's a message that there need not be as serious a consequence for a worker as there is for an officer. But the basis for that distinction, it probably doesn't make sense from a health and safety point of view, but it's where the law has landed. There's this question about if we're prosecuting a company or one of your agencies or your organisations, and we're prosecuting the whole company for workplace manslaughter, whose conduct matters, whose actual behaviours are the ones which prove that the company has broken the law in this really serious way. And when you're drafting these laws, you've got a choice. You can either say, well, the company's behaviour should really only be the behaviour of the directors, the very senior managers. We should only have a sort of a guiding mind who makes decisions on behalf of the whole company. That's one of the legal options. The second legal option is to say, well, it should be the entirety of the organisation has to behave in this way, or a substantial part of it, before we can aggregate up all those individual behaviours to say that adds up to the corporate behaviour. So you either pick the top or you pick the bulk. Those are your options for proving that a company has broken the law. In these laws, a different decision was made. The decision was to say, it really doesn't matter who has behaved in a way that is negligent in order to prove an offence against the company. So long as it is behaviour which is explicitly or implicitly sanctioned by the company, by the organisation, by the agency, then that will do. The prosecution will have proven that was the agency's conduct. And so these are fine legal tests, and I know that to some extent we as we sit here now don't need to decipher them. But I do make the observation that in making the choices about how to prosecute these offences, the government has made it less difficult, although it is still difficult, for a regulator to prosecute a company, because the company, they don't need to prove this aggregation of everyone's conduct. They don't need to prove that the director knew or believed or understood something was happening. In essence, what happens within the company is almost sufficient to prove that is the corporate conduct. And so this is where people have been focused on issues of workplace culture, auditing, assessments, confirmation of the way in which the company is behaving, because there is a risk that the behaviour of one individual or a small number of individuals can be grossed up to be corporate misbehaviour. And that's problematic, but it is, it's again what the law is provided for. The failure has to cause a death, and causation is really critical. A lot of people, for example, have been asking about COVID-19. If somebody catches COVID-19 at work and they go to hospital and they die, would that be a manslaughter prosecution? That's a question I've had a dozen times this week. I think it's extremely, extremely unlikely that would get over this hurdle, that you would be able to prove a sufficient connection between a failure at a really serious high level and that death, when there are so many sort of intervening acts. Causation here is intended to be somebody was sent into an environment that was known to be unsafe. They did the thing which was known to be risky, and that thing then caused death. It's intended to be that sort of closeness of causation. There's 200 years of common law on what causation means in Australia, which I won't bore you with, but the intent is that these laws capture things that are very closely connected with employment. It's not intended that they be remote sort of fourth degree issues. There's a wrinkle in that though, that when these laws are being announced, the Victorian Attorney General gave a press conference, as she's entitled to do, And she was asked, what about a suicide? Suicide's a death. It could have a connection to work, as you can imagine. So could that be prosecuted under these new laws? And she said yes, and that is a strictly legally correct answer. If there was a death that was, a breach of a duty caused by work, criminally negligent, that could be prosecuted. But again, this question of causation means that there would have to be a really clear, expressly clear connection between conduct that happened in the workplace and a death. And if that death was a suicide, there would need to be a very, very close connection between the two things in a way which is often opaque. And for our sins, we often help our clients through a suicide of a worker. And there might be, notes left or emails sent which suggest, some element of workplace connection. But very, very rarely, in my experience, is there a direct connection between workplace conduct and a death. And so again, there's been a bit of perhaps undue concern or even panic that companies are on the hook for a worker suicide. That is not per se correct. There's got to be this clear causal connection between those two things. And just to give you an example, the very worst case of, or the worst publicly available case of workplace bullying that led to a suicide arose in that cafe vamp situation, which I don't know if you recall, but now maybe even 10 years ago, a young waitress, a kid, was working at a cafe with two, awful people, three, I think, and they hectored her to death, effectively. They bullied her, they made fun of her, she attempted suicide, they mocked her for not actually being successful. She made a second attempt and she was successful and she passed away. In those circumstances, WorkSafe, even then, did not prosecute those people with the most serious offence it had in its arsenal, that Section 32 breach. Now, whether they would prosecute with these manslaughter laws, I reckon the world has moved on a lot since Brodie Fanlock's death, and partly, as a result of it. Brodie's law, there's a lot more said about bullying, there's a lot more said about suicide. So the political, as it were, expectations might be different for the regulator. But I just make the observation that it's that sort of case which I think is a suicide has to be connected with work to bring these sorts of prosecutions.
Steve, there's just a question in the chat that relates to causation, and it's from Fatten at McKillop, and it's how about causation as it relates to clients rather than employees?
Sure. Well, I think that's, Fatten, I don't know if you want to elaborate on the question. I don't know if you can unmute yourself. Perhaps you can, perhaps you can't.
Hi, Steve. Can you hear me?
Yeah, we can, Fatten. If you want to give me your question, I'd love to hear more about what you want to know.
So McKillop obviously looks after clients in family services space as well as children in foster care and residential care. Sure. And so, one of the questions that I have is we obviously deal with a very vulnerable cohort of people, yep, different circumstances, and whether, I know you've given examples where it's been employee deaths and the connection is more of a workplace employment law focus, but when you're dealing with the duty of care to clients, yep, how that relates to causation, and does that alter the threshold requirement around it?
Yeah, look, and we've helped some people in your sector with terrible cases where there's been deaths, including deaths in some of the facilities that people are housed in. I think in a practical sense, a death of a client isn't of itself, simply because they were a client of yours and they've engaged in, for example, risk-taking behaviour, or they've been engaged in drug use, or even even tragically a suicide. Just because they're connected with your organisation, I think the point of this causation test would be that would be insufficient for them to, for you as an organisation or your senior leaders to be susceptible. There would really have to be a failure of your system. And that might be your system of supervising, it might be your system of welfare checks on your clients, it might be your system of managing occupational violence risk from other clients. That is the thing that is going to be the subject of a focus in these sorts of investigations and prosecutions. So there has to be something that we ought to have really done differently, or that our system required us to do differently, that we failed to do, which caused the death, to get over this second hurdle. Now, let alone the last two hurdles, but there would need to be that sort of connection.
Right.
I'm not sure if that helps.
Yes, it does. Thanks.
Yeah. So let's go to this question of negligence now. So this is the standard that's applied. First and foremost, there's an element of the negligence test, and we'll come to what that really means in a second, because negligence means all things to all people, right? Negligence is me tripping over a crack in the pavement that the council's not fixed. It's slipping on a grape at Coles or Woolworths, and it's not to suggest that that's the legal test which is being applied here. But it's a harrowing word to use, because it suggests that anything that sort of falls anywhere below the reasonable care standard can be prosecuted for manslaughter, and that's not the test. So I'll take that in a second. But the first element needs to be that there's an element of high risk work. And I think the reason, it's unclear, to be frank, why this is an element of the test, but I think the reason is that this is intended to capture known, foreseeable failures, as opposed to those 1 in a million events where the risk was not able to be calculated as being high because of the unforeseeable nature of the activity. So the first question is, are we dealing with something high risk? Now, of course, you in your businesses, as part of what you do, you naturally deal with high risk activities. So this isn't a complete answer, but it's useful to know, I suppose, that there's a further narrowing of the sorts of things that can be found to be negligent. So then we get to the crux of this, which is, what's the standard that's got to be applied? So the prosecution has to prove that your behaviour was a great falling short of the standard of care that would be taken by a reasonable person in your circumstances, a reasonable employer or a reasonable individual. A great falling short. So if any of us today get arrested by Victoria Police and charged with manslaughter, ordinary manslaughter, whatever that might look like, in a car or because of something that was done, we can be taken to court and prosecuted for manslaughter under the Crimes Act, and the jury is told, has Steve's conduct been such a great falling short of the standard of care that somebody would have taken in his circumstance that resulted in the death of a person, which warrants the sanction of the criminal law. That's the bit that's on the end of the ordinary manslaughter test. Of interest, and it's not a major point, but it's not an insignificant point. A jury who will be asked to determine whether a company has committed workplace manslaughter or an officer won't be given those last few words, won't be reminded that the test is intended to warrant the sanction of the criminal law in a very serious way. That language has been dropped off the statutory definition of negligence. So I make that observation. Again, I just want to give the sense, I suppose, not that this is an easy offence for the prosecutor to prove, but it's not been made as impossibly difficult as perhaps proving an ordinary manslaughter prosecution under the Crimes Act. So the prosecution has to come to you, go before a jury, as it will be in Victoria. These cases will be run by the Director of Public Prosecution, and the Director will have to go to the jury and show that the conduct didn't just miss the standard of care by a little bit, which in essence is the reasonably practicable test. That's the test that applies under the health and safety law for all the other offences, most of the other offences. They'll have to show that your behaviour was miles away from what a reasonable person would have done to protect life and limb in these circumstances. A great falling short. So, 1,000 barristers will have 1,000 beach houses arguing the toss about what is a great falling short of the standard of care in this context. But I suppose I want to give you a sense that to bring a manslaughter prosecution has to be a reasonably obvious failure to have taken care for somebody else. I saw a question pop up then, Emma. I have a further comment about this, but does the question relate to this slide?
There was a couple of questions, and I wasn't sure if you wanted to come back to them at the end. There's one from Francis in relation to causation in a residential unit. So during COVID, if you work in a residential unit and there is a resident being cared for who has COVID, and you have been asked to work in that unit and you contract COVID and die, is there a potential for a manslaughter case? So I think it's just that knowledge that someone in the unit has the disease and that you're being requested to work in it.
That's a really difficult situation, but of course, there is a risk of infectious disease for somebody you're caring for today. Well, not today. Let's call February. There's always a risk, I suppose, of infectious disease, and there's always a risk that one of your workers can contract it and die. is every time that occurs a potential manslaughter offence, the position would be no, so long as it was clear that we had taken and directed and supported that employee to mitigate the risk of contracting that particular illness. Now, COVID is in our psyche because it's a particularly contagious disease. It's not actually a particularly fatal disease, it's a particularly contagious disease, and if you get enough people who catch it, you end up with a higher proportion who are at risk of dying. It's that contagious element that we owe an obligation, all of us, my business, yours, owe an obligation to try and mitigate for all of our employees. In circumstances where we are on notice that somebody has COVID, then the question is, well, what can we do to care for that person if we're obliged to, if they've been told to work from, remain in the residence, which I think is unlikely for what it's worth. I think in those circumstances, hospital beds would remain available. But nevertheless, in the event that they were, our job is to continue to provide care for them if we reasonably safely can, and that goes to providing all of the PPE and disinfecting and social distancing requirements as best we possibly can.
Would the same be true, Steve? This is Kate Barber speaking. If it's just staff and staff, so say, for example, as we start to reopen our workplaces, we're all working at home at the moment,
Sure.
and we can't demonstrate that we've put all the things we need to in place, and people catch it from each other. Is that something?
Yeah, that's problematic. Is it gross negligence and manslaughter? I mean, as I say, I really think this is at the absolute periphery. So I guess my advice to you would be this: don't think of this as a manslaughter risk. Think of this as ordinary health and safety risk management. What are the things we can do that can genuinely mitigate the risk for our people? What is the guidance material from WorkSafe in Victoria, or as a great reference point, the Safe Work Australia website? What does that require us to do, or suggest that we do? And are we satisfied that we've achieved that? I mean, I think that's the best way of thinking about the COVID risk. It's an opportunity to undertake a fresh hazard and risk assessment in the business, to have reference to that external guidance material, and to measure ourselves against that, and to consult with our people, to engage with those workers and be satisfied, that they're comfortable to return to work. That's the way I would view the COVID risk. I think to think of it as a manslaughter risk is to put it out of its field of play. I really think it's actually much more likely to be an area of potential, improvement notice style enforcement action from the regulator rather than, a manslaughter offence. I suppose I'll just make that point. Just very briefly now, I've been speaking about the offences as they apply generally, and I've told you that principally these will be prosecuted against companies, but it is worth noting that there is a potential for officers, that is, people who are, and if you're an incorporated organisation, somebody who fulfills the sort of ASIC test of an officer, they're a director on the ASIC search, they're a CEO, they're an executive. Those are people who are expressly defined to be officers under the Corps Act. If you're an association, an unincorporated association, the Health and Safety Act deals with that as well and basically applies the same test. Are you in the most senior level of organisation? These are the people who are expressly susceptible to a manslaughter prosecution. Remember, workers have been carved out. There's a few quirks to how the law has been drafted, which I won't labour, but I will note that there is a theoretical risk, at least, that if a human being is said to be in management and control of a workplace, and conceivably that can be somebody in charge of a residential facility, for example, in your sector, they might also be susceptible to these risks. There's a lot of legal fighting to be run and won, but by the time that those cases are proven, I suppose, again, going back to my very preliminary point, doesn't matter, probably not in a fundamental way. People who have those residential, facilities under their care and control already owe a duty of care to manage these fatal risks. And so I think I would approach it as a business as usual, but in the event of a death, there is a genuine risk that will need to be managed, and that might lend itself to you seeking separate legal advice, both for your organisation and for the people who are affected. And that's sort of one of the, like it or not, one of the consequences, I think, of these new laws. So what are we telling people to do? We're telling people not to panic, for what it's worth. your sector is plainly, you know, a potentially high risk sector, and as I've acknowledged at the start, complicated by funding limits and the nuance and the dynamics of your working environment. And you should continue to sort of face into that and to think about risk in a positive risk management sense, engage in consultation with workers, think through available risk controls, and be satisfied that what you're doing is at the very least consistent with the industry participants here. The manslaughter introduction, though, does, I think, call out an opportunity. That's my positive spin, an opportunity to pause and reflect and say, what are the fatal or even catastrophic risks in our organisation? What are the things that can happen that can cause a death? What are the pieces of equipment that can fail and cause a death? What are the systems which, if we don't apply, the worst case scenario is a death? What are those things? And to have that, macabre but important conversation, and then to say, well, are we really clear that what we are doing about those is consistently done and marries up with industry practice? So what are our risk controls? And you might even use the language of what are our critical controls in relation to those fatal risks? And do we think they happen every time? And if they don't, what are we going to do about that? And do we think that what we are asking our people to do is consistent with industry practice? I would engage you to consult with workers about this. And I understand it, but there is a focus, of course, on the legal consequence of a death at the moment. And many organisations and directors and industry bodies are out there telling everyone this is a terrible thing, and directors can go to jail, and there's a sort of a hyping up of all the rhetoric. That is the legal consequence, and that is right, and that is fair, and that's it's the work I do for a living is to manage those risks. But I think the better conversation is actually about that can only arise if somebody dies. So can we talk to our people? Can we engage in consultation with our people about the safety risk? The legal risk is what it is. You've got lawyers for that. The safety risk is yours to hold and to minimise as best you can. And so an engagement in consultation, which doesn't say we're concerned that directors are going to go to jail, how do we solve that problem? A separate discussion that says how do we engage with you about what is working and what is not, about fatal risk. I just think it's time much more well spent. And it's actually consistent with safety as opposed to safety law. And this is a point where those two things don't necessarily marry up. You need to be satisfied you're putting your money where you can do the most good. Are we putting resources where we best can? And again, I appreciate the sort of resource constrained environment that you're in. And secondly, fifthly, finally, are we clear that we've got a really defensible decision-making process? Are we clear what the CEOs of our organisations are accountable for signing off, where she or he gets the information from within the business and why that's reliable information? Do we have a basis on which we can assert there is a genuine culture of compliance here? So there are elements there about what I've called health and safety governance. It's a very highfalutin idea about saying, do we make good decisions and do we implement them well? Those are challenges for lots of organisations and again for yours. So Emma, that's the content I was hoping to deliver, but I'd love to hear any questions as we go through.
Thank you, Steve. That was fantastic and really informative. So we'll open it up to questions, and I think Oliver's going to unmute people to enable that. You can either speak up or pop them in the chat, and I'll just keep an eye on the chat. Are there any questions? I know we've had a few that have come through. Are there any others that people would like to ask Steve while we've got him with us? I know there was a comment earlier in the chat, which was, I think, a comment, not a question, around Anne-Marie Smith's death recently may be an example of neglectful causation. That's from you, Nikhil. I'm not sure if you just wanted to raise that or if you had any comments about that, Steve.
No, I didn't want to go into any further detail. It was just the most recent one where a client had, obviously suffered from what is alleged to have been a neglect by a provider. It was just on the back of the other client question. It wasn't really a question at all.
No, I understand, Nick. Look, and I think, and that is that we've only got, as is always the case, and you know better than I do, you only get a snippet, I suppose, of the story, but none of the snippet looks good for the department or the process it had for undertaking, checks in those circumstances. I guess I'll just make this observation that there was a case in Sydney, New South Wales, a couple of weeks ago, where a child had been killed and another had been left sort of seriously disabled because a subcontractor installing gas, supplying gas into a hospital, had lied on the form that they'd done the necessary checks to satisfy themselves that the right gas was going in the right pipe. You can imagine in a sort of a MICU unit, it matters whether you're getting nitrogen or whether you're getting oxygen, it matters. And by sheer negligence, recklessness, frankly, this contractor had lied on the form and sort of said, yeah, I've done all the checks, that's good to go. And they've been doing this for years, it turns out. And as a result of that, these kids get the wrong gas and someone passes away. So this person gets sentenced. They get a it was $100,000 fine. It's a personal fine, a lot of money, I suppose. But the court said, it's a shame I can't send you to jail because I would have. And I just suppose I give you that as a reference point that probably we are lowering the sorts of events that would lead to a court or the community or a coroner believing that there should be a more serious sanction than just a monetary fine. I think that's a macro trend across society, frankly, and particularly in the area of work health and safety. So that I'll just tell you that because that wouldn't have been a judge's reaction to a health and safety prosecution 5 years ago, to be frank. It just wasn't on the radar that we should be prosecuting people for these most serious things. So events like the Anne-Marie Smith death and the awful story that leads to that, it leads to a visceral reaction from coroners and from judges too, and from regulators. And so if we put this manslaughter prosecution risk in their arsenal, they will use it, and they will use it where they feel that there's a need to punish people. Sorry, long answer, I know, Nick, but I suppose that's my view.
It's Kate Barber again. Could I just ask one other question? When I was I'm not that familiar with the OHS Act, but I was looking at the section about liability of officers because it's saying that's part that's changed. And I just noticed a line in there at the moment which talks about if the officer is a volunteer, they can't be prosecuted. I thought it said for acts they do as a volunteer. Is that right? And does it change with the manslaughter legislation? Because I'm guessing a lot of our boards are potentially volunteer boards.
Yeah, that is right. There is a carve out for volunteers, which is intended to carve out helping at the footy club and doing the sausage sizzle from ordinary health and safety risk. That's the intention of it. But the overlay with officers is interesting. And to be honest, it's only in the past couple of days we've sort of been attuned to that ourselves, this distinction between an officer and a volunteer. I don't want to give you a bum steer on that. What I might do, Kate, it's a really good question, and it's funny, Julie and I were talking about this very issue this morning. What I might do is I might just gather our thoughts on that, and I'll give you Emma, a brief position that you guys can circulate.
Oh, that's fantastic. There's another question from Fadden at McKillop in the chat. I don't know, Fadden, did you want to raise your question or?
It's along the same line of Kate's message around volunteers. So I suppose that you've obviously got the meaning of officer, which extends beyond corporate directors.
Sure.
And so the question that I had was more around if it's the case that the corporate directors themselves are not being prosecuted because they fall within the carve out relating to volunteers, then is the impact of this likely to mean that the WorkSafe will look to the executive as the first line of port if they were to look at prosecuting not just the company but officers of that company in relation to an incident?
Yeah, well, look, these are all decisions that WorkSafe will make, and they'll make them with the Director of Public Prosecutions for what it's worth. So that the Director herself will be, or via her Crown prosecutors, will be involved in these decisions. The focus of WorkSafe tends to be on named, searchable ASIC style directors. And the reason for that is it's actually easier for them to prove that those individuals are in fact officers of the company because they're defined to be officers of the company. So that the trend is towards director prosecutions rather than executives, just on a statistical analysis. But bear in mind the personal conduct to bring a manslaughter prosecution, putting aside the volunteer question, and we'll come back to you on that and square that away, plainly that matters to your sector, perhaps less to my other corporate clients, but I'll give you a position that you guys can rely on.
Thank you.
On the prosecutions though, just be really clear, there has to be a direct relationship between what the person fails to do or does that is criminally negligent and a death. So this is not a sort of an expansion of a duty to oversee or a duty of governance. There are separate provisions for that. So there's Section 144 of our Act and a duty to take reasonable care. But for manslaughter prosecution, there has to be a connection between what the individual, the human being officer has failed to do and the death. And those circumstances, they're going to stand out. We're not going to be left wondering, to be honest, whether that's the case or not. This isn't going to be an esoteric, question about influence or oversight. There's got to be something that somebody's done that is proven to have caused the death and was negligent. So it's going to be much more people are going to be at legal risk if after a death there's a clear connection between what they did and the death.
Does that mean that you're potentially looking at managers further down the line, or the hierarchy being the ones that are looked at in terms of their decision making around, decisions that are made around the care of clients on more of a holistic basis?
I suspect that's right. There would need to be at a board level for your organisations, there would need to be a decision made which directly caused the death. A decision to accept a particular type of risk in the business, a decision to turn a blind eye to a near miss, to not invest resources where they understand those resources can do some good. So there needs to be an actual connection between that behaviour. And your observation might be right, but it might be easier to prove that connection from a CEO than it might be to a director or a community board. That might well be right. For what it's worth, I suppose I'll leave you with this final comment. If you have a look at the prosecution history of the UK, so the UK has had these laws now since 2008, which, God, that seems a long time ago. They've had them for about 12 years. There's been about 40 odd prosecutions and about 25 of those have been successful. So the UK is a huge country, right, compared to Victoria. So think about that scale. It's the exception, not the rule. But I would make this observation. If you look at the cases, and you can sort of, through searches kind of get to the bottom of most of them, the first bunch of prosecutions when the laws were introduced were the very worst sort of behaviour. Telling an apprentice to drive a truck when the brakes didn't work and the brakes fail and the truck drives into a tree and the apprentice dies. The worst sort of monstrous behaviour that probably, was ordinary manslaughter, even if it wasn't industrial manslaughter. They were the first sort of prosecutions that were brought. We're about to have a prosecution in Queensland of a guy who died at a car scrap yard in circumstances where safety was just not a consideration of those people running that business at all, and someone's died as a result. And worse than that, when the investigation came through from the regulator, they lied. They said, well, we think he fell off the back of a truck. We don't know what happened. When they knew full well he'd been hit by a forklift. Mental note, never lie if there's a CCTV footage camera which is taking a video of exactly what happens and you appearing to cover it up. So they're going to sentencing this week. So that is the first manslaughter prosecution in Queensland, right? So this is not good people doing their best but failing and falling marginally short, which describes, the sorts of incidents that might beset your sector. These are people who fall well short of what would be required to look after health and safety. And I do want to leave you with that sort of sense of calibration, that this is really what we're talking about. People who are criminally negligent and cause the death of somebody else. There is already, under the manslaughter laws in the Crimes Act, there is now a specific workplace manslaughter provision. So I wouldn't worry about the legal problems at the back end. You can get supported through that if there's a death. What I would do is instead flip that on its head and say, well, the thing we can do that we can really, do today is re-examine those fatal risks, be clear on the critical controls, ask our people, do we think we're doing the right thing? Are we doing enough? have that question about resourcing, and then think through the decision-making risk management process. I know those are all esoteric ideas that it's hard to do from our living room. Even at the best of times, it's hard to do in the corporate sense. But that is my recommendation to you in this sector. You are not the first sector likely to be prosecuted under these new laws. But that being said, they're not irrelevant to you either. So you've got to kind of calibrate your response somewhere in the middle. Thanks, Emma. Over to you.
Yeah, that's really helpful, the recommendations, and certainly starting with speaking to your people and understanding the risks so that you're not starting at the manslaughter end. I think that's really pertinent and all about the early intervention focus in many aspects of our sector. I'm conscious of time. Were there any final questions for Steve? I think we might have covered the field, but speak up now if there are. As I said earlier, we will circulate these slides, and they're super helpful, particularly the recommendations that you've been focusing on, and they will be available on the website, as will be the recording. And thank you for offering to do that, the note on volunteers. I think that would be incredibly helpful.
Sure, we'll square that away for you.
So just really want to thank you again for your time, Steve, and just reinforce you've done this pro bono for us, and we're greatly appreciative of that, and giving the time to the sector to explain these laws and focusing on what really matters and how they can manage them. So just a couple of comments coming in, thanks, this is really helpful. So just a big thank you from us at the Centre, from VHA and VAADA, who run the TriPEX program, for taking the time and explaining these really important laws to our sector.
Cool. My pleasure, guys. Thank you for what you do. If there's anything I can do to help, just reach out. Emma's got my details, and we'll send you a short email and give you a position on the volunteer thing. Yeah, fantastic. If you send that through to me, Steve, the short position, and I'll send out the slides and your details so anyone can contact you directly. And if there's any feedback on the session, please do not hesitate to send it through. And if there's any further session topics that you would like, please don't hesitate to send them through to me also. So thank you very much. Have a lovely afternoon, and thank you again. Really all the best. Thank you all. Thank you.